All right, have a seat, please. We're ready for Parnell versus Parnell.
Good morning. May it please the court, my name is Beth Coleman and I'm here on behalf of the appellant, Christina Parnell. I'd like to reserve 5 minutes of rebuttal time, please. We're here to ask the court to reverse the lower court's decision that denied the mother's request to move with her small child to Fort Myers to live with her family while she continues her education in order to pursue a better career. The move will provide her and her child, Mason, with emotional and financial support they don't have in Orlando where they currently live. We contend that the lower...
What are you asking us to do ultimately here? What disposition do you want us to make?
To reverse the lower court's decision and permit her to relocate.
Instruct the trial judge to allow her to relocate.
With the child.
Pardon me?
With the child. Right?
With the child,
yeah.
yes.
Does that require us to really substitute our judgment for the trial judge on reweigh all these factors and all that?
No, in this instance, it's important to note that the mother testified and the father didn't. So the bulk of the testimony was uncontradicted, and that testimony supported the various factors under the statute for the grounds for relocation. The mother.
How do we balance the need for this young child to have a relationship with the father against the needs of the child to derive this financial benefit from his mother moving? His or her, I don't remember. Was it a boy or girl?
A boy.
Yeah, boy.
Well, it's important that the key here is the mother did her best to try to make sure that the father, with her proposed visitation schedule based on relocation, she tried to make it so that they would spend essentially as much time as they do together as they do now. It would be on a modified schedule, but she tried to make it for primarily the same amount of time. And the courts require not that you have the same type of visitation schedule or the same type of relationship, but that you have a continuing, meaningful relationship. And so,
well, didn't Dr. Guest? He was the parenting coordinator, was he? That testified.
Correct.
He kind of seemed to say that the mom gave lip service to the co-parenting. That he didn't think she bought into that. Isn't that true?
well, he did cite some things that had occurred at the beginning of when the parties first divorced.
I mean, that was something the trial judge heard and took into consideration.
He did, and we don't think that testimony should have been admitted, but even assuming that it was admissible.
Well, it did. It was, evidently. I know that's one of your issues on appeal.
Right.
Okay.
Assuming that it was admissible, he was talking about things that basically had been resolved. They were things in the beginning when the parties were learning how to communicate and learning how to transfer the child in a way that didn't cause stress, and that got better. Their communication got better when they were corresponding by email as opposed to face-to-face. And there was no evidence at all that the mother had ever, refused to comply with any of the visitation. The father got all of his visitation time. She never failed to comply with the court order. So while Dr. Guest did seem to indicate that, it was based on issues that were primarily in the past. And
could the trial judge have determined on this evidence that the mother's motivations were not genuine?
Well, the judge didn't say that, and again, there was no evidence to that effect. There
was some evidence that she hadn't even taken the GMAT yet, and that she hadn't, didn't that come out on cross-examination? And can't the trial judge kind of factor that in and decide ultimately that she's just making this plan up, so she's got a reason to move and get close to her parents?
Well, again, there's no evidence that she didn't comply with the visitation schedule, and she proposed a visitation. It's not as
But I mean her plan. I mean, this was structured around a plan for her to advance her education less expensively, and that it was going to ultimately benefit the child because she was going to make more money. Could the trial judge have concluded that this was a disingenuous plan?
Well, I don't think based on the uncontradicted testimony there. She had been going to school. She had been working on her prerequisites. She still had several classes she had to take before she was even in a position to take the GMAT and apply to school. But even if you say, okay, the judge just thought that was a pie-in-the-sky idea, it wasn't realistic, there was still no evidence to contradict her immediate needs, which are that she and the child are currently living in a friend's spare bedroom. That's a temporary situation. They need to move. She doesn't have any savings. She doesn't have a job. She has this ability to move in with her parents.
Weren't her parents helping her then too? Correct?
They were helping her, but...
And they were going to help her when she moved to Fort Myers?
Correct. Going forward, that was their offer.
Wasn't that one of the issues? Who's to say they wouldn't continue to help her in Orlando?
Well, there was no evidence that was an offer anymore. Maybe that was, they weren't able to help her in that way anymore, but they were able to help her by, living with them. And
She kind of left out of her plan the fact she'd get child support, that she could work a job, a part-time job that would give her. She just said, I have nothing here, zero, and down there they're going to furnish everything to me. I'm going to have a house and food, the whole works.
Well, and I think she did acknowledge that in either place, yes, she gets child support, yes, she's contemplating getting a part-time job, but it doesn't change the fact that if she has to stay in Orlando, she's going to incur thousands of dollars of more expenses to live there than if she can live with her parents
Part of her
rent-free.
motivation, I think, was that she wanted the child to have a relationship with her family, if you will. Is that
Well,
correct?
and the child already does. He's very close to his maternal grandparents. They go there almost every other weekend. They have extended family there. She's got emotional support from her
Couldn't
family.
the trial judge say, I think it's more important that the child have a relationship with his father as opposed to maybe the cousins and the...
Well, and again, it's important to note that this is not a question of either or, that that the child can have a relationship with the mother in the extent.
Well, it was going to change the dad's visitation, correct?
Correct, and
I
so
mean, he was going to have less,
he was going to have less when he goes to school.
and he was a police or sheriff, wasn't he?
Sheriff's deputy,
So he had
yes.
kind of odd hours, and they
Right.
kind of crafted this thing around
Right.
his work schedule.
Right, and so it's not a question of, let's just, eliminate the father's involvement in his life. There was no evidence that this proposed schedule was going to impair his relationship with the child at all.
Counselor, it seems to me that one of the factors that seemed to weigh heavily on the trial judge's mind was the notion that the husband had a child by a former marriage and I guess lived in New Smyrna Beach, and that there was going to be a very, very difficult timing situation for him to try and maintain a relationship with both children. How do you think that factors into this?
Well, I think it's important that the mother did want to make sure that Mason continued to have a relationship with his half-sister, so she was, proposing that the visitation periods coincided with the time that he has his daughter. And also, currently, he does all the driving to make the drop-offs and the pickup of Mason, and she's offering to drive either halfway or three-quarters of the way to ease that burden on him and, increase the time that he has with Mason as opposed to driving. So it's important to note that while the judge does have the ability to weigh the credibility, she has to do it within the confines of the evidence, and in this case, the evidence about why the mother wanted to move, the emotional and financial benefits that she would receive from that were uncontroverted. There was nothing inherently incredible about them. And she's still proposing a contact schedule that provides for a continuing meaningful relationship, and the father didn't testify, again, at all that wasn't going to be possible.
So what's the legal standard we have to deal with?
Well, to the extent that the court applied a presumption against relocation, which is against the statutory prohibition against that.
How do we know that the trial judge did that?
Well, unfortunately, the trial judge didn't really give us much to go on, so we're sort of speculating. But when you consider the uncontroverted evidence and the fact that you had the mother testifying to all these factors, and the court still said, no, it's not in the child's best interest, it appears as though she went with relocation is always bad for children, which is what the parent coordinator says, and that's clearly against the statute, so that would be reviewed under a de novo standard. To the extent that the judge...
I don't know how we can review a speculative finding. I mean, if you're speculating over whether or not the trial judge applied the wrong presumption, how can we review that?
Well, we contend there's no substantial competent evidence to support the findings, and particularly when you consider the lack of evidence To the contrary, it appears as though a presumption was applied, and the judge said that he relied on the parent coordinator's testimony, and the parent coordinator came out and said, the studies say relocation is bad for children. And we don't think that the parent coordinator should have been permitted to rely on that, but also that's against the statutory
you win on the admissibility of that, they just get we just remand for a new trial.
Correct.
Right? We don't reverse the judgment or direct the trial judge to allow the relocation, right?
Well, to the extent that evidence is inadmissible as a matter of law, then you're left with the uncontroverted evidence of the mother. That's consistent with the statutory factors, and she proved her case at that point. So there's really nothing else to remand and go back to.
Just because she's the only one that testifies doesn't mean that everything's uncontroverted, right? In other words, the trial judge doesn't have to accept everything she says as gospel, right?
Well, to the extent that it's uncontroverted and it's not completely unreasonable or, just beyond reason.
Well, how long was it going to be before she was in a position to apply to graduate school?
I think at the time she had talked about needing 3 more classes. I think it was
No, I mean time-wise. She's got to get some classes before she could even take the GMAT, and then she's got to get the results. And I mean, how long down the road was it going to be before?
I don't recall exactly. It seems to me that it might have been 6 months to a year. But again, she had the immediate need of, needing to move out.
If that's true, then really the issue had to do with the immediate need, not the college plan, right? I mean, the college plan was something that was off in the future and could be revisited at some subsequent time if it became a reality.
Well,
right?
I think it was all together as part of, that's part of why the parents offered to let her live there rent-free, expense-free. She was in the process. It wasn't just sort of a pie-in-the-sky idea that she came up with. She had actually been taking classes, getting her prerequisites out of the way, working towards her degree.
So the teaching point of this case, the rule of law that you espouse, is that whenever the maternal grandparents offer to allow the mother to live free, that relocation is we ought to direct a relocation.
No. And it's not simply that's one factor. The financial factor was part of it. It was also the emotional factor. Mason's very close to his grandparents. He can be cared for by them as opposed to being in daycare and being cared for by strangers.
Right.
And again, you're looking at the fact that this is not a situation. It's a situation that's going to improve the child's life. It's going to improve the mother's life. And there's no evidence that it's actually going to be detrimental to the child or his relationship with his father, other than simply speculating and saying relocation is just a bad thing. I basically think that, you have to be physically close to your children in order to have a close relationship with them, and there was no evidence of that in this case, and the statute doesn't let you presume that.
You want to address the evidentiary issue?
Yes. We contend that the expert shouldn't have been, Dr. Guest shouldn't have been permitted to testify as an expert because he wasn't listed that way in the pretrial statement as required by the pretrial order, and shouldn't have been permitted to bolster his testimony with the Braver study. He also shouldn't have been permitted to testify as a fact witness because he didn't have sufficient personal knowledge. He didn't do any study, he didn't interview the child, he didn't do any home studies. Really, the extent of his observation of the parents' interaction with the child involved, seeing them for a couple minutes in the waiting room while the parents were waiting for their appointments with him. And when you have a situation where an expert is testifying like that, not based on personal knowledge, that can't constitute competent substantial evidence in support of the decision. And the father has suggested that even if that's the case, it's harmless error or the court didn't rely on it, but you can't presume that in this instance, where his was the only testimony in response to the mother's motion. The court specifically admitted it over objection and said that it relied on that testimony. Again, in the Lieberman case, this court has said you can't presume, even judges, that the human mind is capable of just obliterating what it heard, even if it turns out that it decided that wasn't appropriate evidence to hear in the first place. And again, given the lack of findings, it appears that that evidence was very pivotal to the court. And again, that evidence also is contrary to the statutory prohibition against presuming that relocation is bad, or that if the visitation schedule is going to change, that you can't relocate.
You have about 5 minutes left.
Okay, I think I'll reserve. Thank you.
If it pleases the court, James Campbell for Brett Parnell. I would like to expand a little bit about the history of this case. If the court needs to know that in July of 2007 this case was filed, and in the original petition, Ms. Parnell asked for a relocation. The case went on until March of 2008, and at the trial, she did. She wanted to move back home.
Yeah.
So she had lawyer Linda Scribner, and then she had Charles Dellinger for the trial. And at the trial, she dropped that request. But in that intervening 8 months, as Judge Alley could see, she spent $25,000, $26,000 in legal fees moving forward on that. She did not want Mr. Parnell to have overnights. She did not want, and she wanted to move to Fort Myers. She dropped that. Justice Perry gave my client overnights. After he gave her overnights, she hired Norma Ben, and she spent another $12,000 on a motion for rehearing, in which she hired experts, and her mother filed an affidavit. She filed an affidavit that overnights was not good for a young child for the father. Judge Perry summarily denied that. So we come up to November of 2008, and Judge appoints Dr. Guest. And the order appointing Dr. Guest was prepared by Mr. Levine's office. It's a very unusual order because it gives Dr. Guest a lot of power, but he never used it. So, and then he starts in November of 2008. Less than 2 months later, she files another petition to relocate, in which she told, and Dr. Guest testified, Mrs. Parnell did not want to have overnights. She wanted to move to Fort Myers, and she thought moving to Fort Myers was not worthy of discussion in a parenting coordinator situation. Excuse me. So we come with that setting. She's had it once. She's here again, and we have the setting that when she comes, she's had 6 months to prepare for the hearing. She hasn't, as Judge Torpey said, she hasn't taken the GMAT. She hasn't applied for financial aid. She hasn't even applied to the school in Fort Myers. She hasn't given any testimony about applying for a part-time job here or there. And her parents, at this point, had paid close to $40,000 in lawyers, and it would be pretty reasonable to assume, Judge Alley would say, and she asked her, and the question was asked, are your parents going to support you in Orlando? They're going to support you in Fort Myers, or they're going to support you in Orlando? She couldn't answer the question. She said she never asked them. So if you look at the trial court in the trenches there with Mrs. Parnell, I think she had a very good opportunity to observe and understand what this was about. This was not about the best interests of Mason Parnell. It was about what's going to make Christina happier. She's going to be with her parents. She even says, incredulously, she said, because Mason can wake up in the morning and see his grandparents. So if she had a plan, and Judge Alley says her plan is not believable because she hasn't done all these things I've mentioned.
Did she make that finding particularly?
Well, she says she found the plan to be, it's a 2-page order. She said the plan not to be believable or credible. So the plan itself failed on its face. I mean, we never had the opportunity for Mr. Parnell to even testify because she found on its face it didn't meet the criteria. She didn't say there's any presumption against moving. Ms. Coleman says that, but it's nowhere in the record. And when Dr. Guest testified, when the Beaver study came up in the transcript, her lawyer didn't object to that study. There's no objection to Beaver being mentioned. And Judge Alley obviously had read it. She understood it. She confronted Dr. Guest about it. So I think his testimony, at best, was harmless because he was there as a parenting coordinator, and Judge Alley was wanted his input. She said, he's my witness. She ordered that he appear as a court witness. So therefore, I think that the record is complete with enough evidence, more than enough evidence, for Judge Alley to deny this relocation based on the criteria in the statute. Ms. Coleman says the judge didn't take the statute into consideration. The attorney, Ms. Sedlow, argued the case, went through A through I, each point in her summary argument as to why she felt that she had prevailed. So, to me, it doesn't seem reasonable that why would Judge Alley not know the law when Ms. Parnell's lawyer laid it out for her, A through I. Mrs. Diltz talked about it, and the judge was familiar with it, and she applied the right rule of law to this case. And therefore, we think the court should affirm the judge's decision. Any questions? Thank you.
All right, Ms. Coleman, you have under 5 minutes.
Well, first of all, I wasn't involved in the court below. I realize Mr. Campbell was, but I don't think there's anywhere in the record as to how many thousands of dollars the mother spent on lawyers' fees or whether her parents paid for it or anything else. I don't think that's in the record. But again, the fact that, and there was the mention of the fact that she didn't want overnights. And yes, that's true. When Mason was very little, when he was a baby, she didn't think it was appropriate for him to be away from his mother overnight. She lost on that issue, and she never failed to comply with the overnight visits or any other visitation schedule that was ordered by the court. There was discussion about the fact that, her plan is not credible because she didn't apply for financial aid, she didn't apply to school, she didn't apply for any part-time job. She was in limbo. She didn't know where she was going to be permitted to live. Obviously, she's not going to apply to school in Orlando if she's going to end up going to school over in Fort Myers. So I don't think that goes to the fact that her plan was not credible. That was just the situation she was facing until the court, either granted or denied her request.
The trial judge found that her plan was not credible.
The trial judge found her plan was not credible.
And you're stuck with that on appeal, right? That finding.
Well,
if there's substantial competent evidence, you're stuck.
Yeah, as if there's substantial competent evidence. In this situation, again, it's uncontroverted. And let's keep in mind what the judge found was not credible. The only thing she mentioned was the fact that, the plan for visitation, she said, wasn't in the child's best interest. Again, that goes back to the fact that the visitation schedule doesn't have to stay the same. It just has to be enough to foster a continuing, meaningful relationship. And she said, I don't like, the expenses, the way she factored in the income and the expenses. She didn't say, no, you weren't going to get a significant financial or emotional benefit by moving to Fort Myers with the parents. No, Mason's not going to benefit.
Well, how does one controvert that kind of self-serving evidence? I mean, you can't really controvert it. I mean, the grandmother testifies that she's got a close relationship with the boy. The mother says there's a close relationship. I mean, it's not really the kind of thing.
Well, the father could have come in and said, here's the relationship he has with me. Here's the things that I do with him that I can't do if he's not here, close to me. Here, I mean, there have been cases where there was testimony about, yes, the parents, don't actually get along, and, the grandparents don't get along. I mean, there are plenty of things that could have come in that could have controverted that, but didn't. And in fact, the parent coordinator himself even said there's going to be an emotional benefit to the mother and the child by her having the support of her family. And you're also talking about the fact that if she stays in Orlando, goes to school, gets a job, whatever the case may be, he's going to have to be cared for in daycare by strangers as opposed to with his grandparents that he already has a close relationship with. There also this discussion about, co-parenting. The parent coordinator also, one of the few things that he had personal knowledge of was the way these parents communicated with each other, and he agreed they communicate better by email, which obviously the parents can do no matter where they live. Face-to-face was not helping this party's relationship and caring for the child. Again, you can't discount the fact, this is not a matter of her wanting to, trade the father's relationship for a pool, but you can't discount the fact that, if they are living with their parents, they have separate bedrooms, You know, he has a nice yard to play in. He's got the extended family members again, so that's also a benefit, and there was nothing to contradict that as well. And again, the father never came in and said, look, if she moves, I'm not going to be able to have a relationship with my child. It's going to, you know, impair my relationship. There was no evidence to that effect. So again, where you have a situation where the mother's uncontroversial testimony was not inherently improbable, unreasonable, it can't be wholly disregarded or arbitrarily rejected. It has to be accepted as proof of the issue for which it's tendered, even though it's given by an interested party. That's in the Dugan case that we cited. And again, to the extent that the court based its decision on a presumption against relocation or the fact that the parenting schedule would change, those are impermissible factors and didn't support denying the motion to relocate. So we ask the court to reverse.
Thank you.
you.
All right. We will